Welcome to the first ever AI conference hosted by the ACC National Capital Region chapter. First, we'd like to thank you for your flexibility today. Our first program scheduled for 9 o'clock this morning needed to be postponed due to a last-minute emergency. We do intend to reschedule the program, and please be on the lookout for a message from the chapter regarding exactly when that will occur. Now, today's event is hosted by the chapter's Technology and Intellectual Property Committee, Ethics and Compliance Committee, and Employment and Labor Committee. We'd like to also thank the law firms Polzanelli, Davis Wright Tremaine, Williams and Connolly, and Haynes Boone for sponsoring this event. My name is Steve Tibbetts, and along with my Tech and IP Committee colleague and President-elect Angie Stinson and Ethics and Compliance Committee Co-Chair Karina Vollmer, we wish you a warm welcome. Thank you for joining us today, and we are excited to continue our AI-oriented programming.
Hello, welcome back to everyone who has been with us already for ACC NCR's AI conference. ACC National Capital Region and our sponsor, Haynes Boone, are pleased to present this webcast program, State of AI, Copyright Law, and U.S. Government Procurement. My name is Angie Stinson. I've seen you all a couple of times today. I'm an Associate General Counsel at the National Student Clearinghouse, ACC NCR President-elect, and a member of the Tech and IP Committee, which is one of the committees putting on today's program. I'll serve as the chapter's host for this program. The program is being recorded. The presentation may be downloaded from the link in the reminder email sent to registrants yesterday. If you didn't receive the email, please check your quarantine or junk folder. A copy of the presentation will also be placed in the chat so that you may download it from Zoom. If you need a copy of the presentation sent directly to you, please email Janine Nguyen. If you've dialed in today's program by telephone, please note that you will not be able to receive CLE credit. To comply with Virginia CLE rules, you need to be logged in using your name and company. If you have any trouble with sound, you're welcome to turn on the captions for a running transcript. Look for the tool to enable captions in the More option at the bottom of your screen. This program will last approximately 60 minutes. You may pose a question or offer a comment at any time during the program using the chat. The panel will address questions as time permits. However, to ensure that we have sufficient time for the prepared content, the panel may need to hold questions until the end of the program. All remarks made by today's panelists are their own opinions, do not constitute legal advice, or necessarily reflect the viewpoints of their company, firm, or of ACC NCR. And now it's my pleasure to introduce our panelists for this program. Dina Blickstein is a partner at Haynes Boone and co-chair of the firm's AI and Deep Learning Practice Group. She focuses her practice on intellectual property, providing strategic guidance to clients navigating the legal challenges of AI-generated content and machine learning technologies. Dan Ramish is a partner at Haynes Boone, where he leverages his experience in the government contracts and white-collar practice groups to advise clients on the regulatory and litigation risks associated with AI adoption. He helps corporations manage legal exposure in supply chain operations and defense-related AI integration. And Raquel Buckley is Senior Patent Counsel and Head of Business Engagement at PayPal, where she manages complex intellectual property portfolios and counsels the business on AI-related innovation. She brings significant in-house experience in evaluating new technologies and aligning IP strategy with the evolving IP landscape. And now, let's begin the program.
Thank you, Angie. Appreciate it. So let's begin. AI is embedded in everything we do, right? In the way companies operate, in the way we interact with consumers, in the way we code. And so we thought that it'd be useful by starting off with understanding the technology and what it all entails. The legal framework is still working to keep up. And so it's up to the courts to still decide how we're going to have these foundational questions addressed. So let's start with the basics. What is AI? AI is the broadest category. It is a technique that enables machines to simulate human reasoning. This is found everywhere in robotics, in EV cars, in search algorithms. Within this is a subset called machine learning. And that is what we hear about everywhere we go. It is the system that explicitly learns from data instead of it being programmed like it was conventionally done. there are two types of machine learning models. There are predictive models and there's generative AI models. And as the name suggests, with predictive models, you're taking all this data in and making predictions. You're analyzing this historical data to forecast outcomes. These type of models are very useful when you have fraud detection, risk assessment, or even search, results for a user. Generative AI models take this data that is being fed into them, and rather than predict it, it actually generates new data, new images, new audio, new code. And so it's learning from the data that it's getting to generate, some of these outputs. And that, as you could see, is where some of the core legal problems come from. It's the data that's being used to train that is making these new generation of information. And I would be remiss if I don't mention at least agentic AI. It's not the core here, but it is good to know that this is the orchestrator. It's essentially using these models to, meet an end goal. Get me a ticket, get my full itinerary of a trip to Hawaii. This is my prompt that indicates what I want to do. And so it orchestrates, it plans, it reasons, it executes to get that user that end goal. Now, before we go into the legal aspect of it, I think it would be interesting to understand how mechanically these models work, because it's understanding the architecture that helps us make some of those legal arguments. So how do they work? Dan, would you please move on to the next one? Overall, the key architecture and the most common is called a neural network. And it's the fundamental architecture behind a lot of the AI systems. What's unique about it is that it's structured much like a human brain. And so it has all these hidden layers and what we call neurons. We start with the input, like I said, we start with this raw data, and it's a mixture of tokens, pixels, waveforms that are used to train the model. Now, within it are these hidden layers, and this is where the actual learning happens. It's the interconnection of these nodes or neurons that are organized in layers. And the deeper you go into the layers, the processing of the data, the learning of the patterns, the predictions start occurring. And so, again, the deeper you go, the more information you get about how you want to make this prediction or this output, but it's also more difficult to understand how the models are making these predictions. Now, one key thing to understand is that within these hidden layers, we also have what are called weights. And these are parameters that are used to determine what are the strength between these different neurons that are interconnected. And that helps make some of these predictions. Some of these predictions are also very, very complex. And so you'll see that there might be, billions of parameters. And so again, the context and the problem with what becomes derivative work and what becomes a derivative copy, comes into question. So we know what's happening within the AI model. Let's learn about how we train the model so that it could be used, and then we'll lead into how we actually get from a prompt to an execution. The training of the models is, very standard. Again, it's all about the data that you start with. You have the source material. It could be articles, books, images, source code, web pages, all this information that gets scraped. Question is, where is this data coming from? How is it being used? Is it legal content? All that comes into play when we're looking at the importance here with copyright. Once the source data has been ingested, the next thing to do is to clean it. And that just means getting rid of the noise, the redundancies, the headers, the footers, periods, so that then we have this clean version that the machine can start working with. Because the data is so vast, we get a tokenized copy. And that is simply a mathematical representation of the data. It is the fundamental unit of data that is being processed by these models. And it's generally a couple of characters long, so that it becomes, a series of short sequences. So if you have a long word, it essentially splits the word into short sequences of characters that make up the word. And it just helps with some of that computational complexity that comes into play. So we've got the information that's not being transformed into tokens, and we start learning from it. This is where we're adjusting the weights. This is where we're going into that network to get some statistical patterns in place and do those pattern recognitions so that then we can start making some of those recommendations and decisions. But before we do that, the model also keeps or retains a compressed copy of these tokens. And so again, we're no longer looking at the raw data, but we're looking at a stored pattern of the data after it has been tokenized. So we know how the data are trained. We see an issue there, right? Because we're no longer working with the raw data. We don't know where the raw data came into play. Another concept is, so now we're using the data. Are there other issues here that may be emphasized and where copyright may be exposed? So to walk through how the model works, you start with the prompt. Everybody's familiar, get me this output, create a PowerPoint for me. The problem is, again, there's a risk. What you put in the prompt, could it contain proprietary data, trade secret, client information? Is this data or that I input into the prompt being retained by the vendors? So we move from the prompt into the model. It does the data processing, it adjusts, it learns from the weights, and there's no visible action here. But what we're seeing here is that influences the output, which is either predicted or generated most of the time, right? And this output is where, again, we could see some liability come into play. What we do have in place is that most models also contain a filter. And these filters are there for safety and for content. Safety in terms of, make sure that we're not exposing information that shouldn't be exposed, but also to provide more focused results for the user. So you want to make sure that you're giving them the details that they want for the goal that they're requesting. And finally, you get the output to the user. Now we understand, what the architecture looks like, what the model is when it's being trained, and then the outputs. It's important to understand how the courts are using this architecture to address some of the copyright issues that are coming in. Dina, over to you.
All right. Thanks, Raquel, for that introduction. And the training and the inference stages that Raquel was talking about on the two previous slides tie in directly with the copyright infringement. So here's the copyright infringement statute. It's 17 USC 501 Section A. It essentially says anyone who violates exclusive rights of the copyright owner is an infringer. So as Raquel mentioned, AI models are being trained on data, right? And the more data you have and the more data variety, the better it is for model training, right? So these data sets are essentially composed of material, which can be scraped from the internet, can be material from shadow libraries, and can also be legitimate content. Right, so that led to the concern whether training AI models on these data sets constitutes copyright infringement. And the other concern is whether AI models produce output, right? So that could be an output before or after the filter that can be copyrighted content because the models were initially trained on the copyrighted content. So then if you go to the next slide, as a result of all these models that were released, with ChatGPT being released in November of 2022, there have been explosion of copyright litigation, both in US and abroad, right? So if we start with 2024, there was more than 30 major copyright lawsuits that were filed. And in this initial wave, primary drivers were artists, Getty Images, and early author copyright lawsuits, right? 2025 was an explosion year, where the number of AI copyright lawsuits essentially doubled, with around 70 cases pending by the end of 2025. Right, but the plaintiffs also shifted. So you have this shift from artists and image creators to authors, publishers, and news organizations, because as AI models were getting more sophisticated, they needed more content, and to some extent, more copyrighted content to train on. Forward to 2026, it's May. We're 5 months in. Right now, there's 80 to 90 cases pending. It's over 100 if you think worldwide. Some of these cases have been consolidated, so the numbers that you can see may actually be less, but if you take individual cases, it is over 100. What you can see from the slide, there's two jurisdictions that come into play. It's Northern District of California and Southern District of New York. In Northern District of California, there's more than 30 cases that were filed. And here you have companies such as Stability AI, Midjourney, Meta, GitHub, and Microsoft. And the litigation is largely focused on image generation, open source coding licensing, LLM training on various copyrighted or pirated datasets. In New York, the situation is different. It says 15 cases, but those are consolidated. So when they're not consolidated, it's also closer to 30. And here the litigation is mostly driven by OpenAI and Microsoft and New York Times litigation, right? So it will involve companies that generate news, produce news articles, media publishers, and the like. The takeaway from this, you have two districts that are heavily involved in AI copyright litigation. You have San Francisco, where you have a lot of AI companies being headquartered. And then you have New York, where you have publishing and media industries. All right, so let's go to the next slide, Dan. So who are the defendants? I created this slide to highlight the usual suspects for AI copyright lawsuits. We have OpenAI, and to some extent, they were the first ones to release the LLM model, ChatGPT. So they're subject to 15 to 20 cases, mostly with obtaining copyrighted data sets to train their AI model. Have Meta, right? So the Meta has its Lambda model, which is also being trained on pirated books. Then you have Stability and Midjourney. So those two were subject to the earlier litigations, and this was for image generation and also model training on copyrighted images. Anthropic is a big one because Anthropic has Claude, and Anthropic case, which I will discuss later, was the one that actually first to reach summary judgment case where the judge applied the four-factor fair use test. Microsoft is involved, and Microsoft is involved in the Copilot code training litigation together with OpenAI. And finally, Google has a few cases as well, and that's from training its Gemini and image models. All right, so if you go to the next slide, here I clustered the litigation clusters differently, so it's easier to spot the issues. All right, so you have the biggest one is with LLM training on books and news. And that's because, as Raquel said, AI models need a lot of data sets to be trained so they can predict once trained, they can predict the code, the texts, and the images. The next one is code generation and open source licensing. This is becoming a very hot area just because a lot of developers are using AI models to help them code, to expedite code development. Image generation, right? So here you have Stability, Midjourney, and Adobe generating images and hence running them into image lawsuits. There's style, mimicry, and derivative output claims. So here, these lawsuits are essentially focused at the AI model output more so than AI model training. And again, this is mostly for image generation, which is Midjourney, Stability, and OpenAI. The media publisher and news aggregation claims. So these are big in New York and subject to OpenAI and New York Times litigation. So these lawsuits largely focus on news articles summarization and essentially using the news articles to train AI models to summarize the news. Finally, the last one, that's the data aggregators and intermediate. So over here, the lawsuit focuses on providing the AI data sets that can be trained or fine-tuned, train or fine-tune AI models. So here the culprits are Stability AI, Meta, and Anthropic. So fair use, Dan, if you can go to the next slide. Fair use is a defense to copyright infringement. And you have four factors that are on the screen. The first one is the purpose and character of use. The core question here is how the work is being used, right? And the focus is on a transformative use. Is the use new, or does the use add meaning, function, or purpose to the existing work? Traditionally, commercial uses weigh against fair use. And as we know now, most AI models are commercial, but it's not determinative. If you look at the AI context, and this is also going back to what Raquel said about AI models being trained, right? The training is highly transformative because the AI models are not, rather, the copyrighted works are not stored as themselves in the AI model, right? They're more stored as tokens, transformed tokens, and patterns, right? So the use of the copyrighted content, whether it's images, a song, or text, is highly transformative, right? The second factor is the nature of the copyrighted work, right? And here the courts tend to look at whether the work is creative or factual. You have creative works that receive stronger protection, and then published works also receive stronger protection. Now, most AI models are trained on highly creative works, which typically weighs against fair use. However, for purposes of AI, the courts tend to construe this factor and give this factor less weight than factor number one because the use is highly transformative. Factor three is the amount of and substantiality of the work being copied. Right. So here the courts look whether the entire work is copied or whether the heart of the work is copied. Now, for AI model training, essentially the entire work is being copied, which is normally against fair use. But the courts here also held that you need the entire work to train the model, and that is reasonable in the relation to the purpose, right? And the purpose here is AI training. The final factor is the effect of the use on the potential market. So this is the most important factor to counterweigh factor one, which is the purpose and the character of use. And here the courts ask whether one, the use substitutes the original work, or two, harms existing or reasonably foreseeable markets, right? And one of those markets can be either the work itself or licensing. Now, if we look at AI models, right, the AI models rarely replicate original content because of the guardrails or filters. We can filter the original content out, right? Additionally, for AI models, their purpose is not to replicate the content, right? It's to train the model itself. So for in AI copyright suits, the market harm is incredibly difficult to show. Now, if you're going to go to the next slide. So I will discuss three cases. The first one being Anthropic. So this case is part of the initial wave of AI copyright lawsuits filed in 2023, targeting LLM model training. So Anthropic has Claude by authors alleging large-scale ingestion of copyright books. Right, so here you have two sources of books. The first source is the pirated and shadow libraries. And the second source, it's lawfully obtained copies, whether they were purchased, stripped, and photocopied, licensed, or obtained from legitimate public sources. This is one of the first cases to reach a substantive ruling. And additionally, this is Judge William Alsop's case, who is also known for influential technology and IP decisions. And this case now is being used as a framework to determine whether where fair use can be a defense to copyright infringement of 4I cases. So for the pirated books from shadow libraries, the court held on summary judgment that there is copyright infringement and fair use is not a defense. For the lawfully obtained copies, the court applied the four-factor test and essentially found the work to be highly transformative. Right. So the court looked at factor one, essentially said that you have these copyrighted data sets legitimately obtained, but their nature is highly transformative because the AI model is essentially storing tokens or process tokens within the model. The court looked at factor two, nature of the copyrighted work, and found that yes, Anthropic trained on highly creative published works, but at the same time, the court gave it less weight because of the highly transformative nature of the training under factor one. Factor three, right, amount of substantiality of use. The court held that both quantity and quality were essentially insufficient, right? Anthropic copied entire works, but at the same time, the court found that the amount to be reasonable in relation to the transformative nature of the work. So essentially, the whole books were copied, but because the nature was transformative to train AI model, the court found that yes, this was slightly in favor of the authors, but not as strong as factor one. Factor four, right, effect on the market. The court essentially said that the AI models don't substitute the original works. So the harm is not foreseeable or predictable. And the court couldn't determine market harm, and the authors had difficulty in showing it. Right. And again, this is for two reasons, right? One is AI models are not meant to replace books or images. And the second one is the guardrails, right? When the AI models are trained and generating input, the guardrails can make sure that the final content is different. So the original copy, the original work, whether it's text or image, is rarely reproduced. So the takeaway from the Anthropic case is twofold, right? So for training, right? Training on legitimate data sets, that's permissible because under fair use, the use is transformative. The second one, the data sourcing, where the books were obtained from pirated libraries, that's not fair use. That's copyright infringement. And as a result of that, Anthropic settled the litigation for $1.5 billion, which is still waiting to be verified by the court. The next case, which is Kadri v. Meta. So very similar to Anthropic, you have authors, and including Richard Kadri and Sarah Silverman, alleged Meta used copyrighted books to train the llama models, again, without permission. Right. And again, the sources varied. There were pirated sources, which were shadow libraries, such as Book3, public web crawling, and also the legitimate licensed text corpus. Now, why am I talking about this case? So the fair use application was largely similar, except Judge Chabria introduced this market dilution theory under Factor 4, right? So the judge flagged this theory for the plaintiffs as a way to determine sort of like the legitimate market harm. So what the authors are typically argued under Factor 4, right, is there is an adverse effect on the market because one, of book substitution, AI replaces a specific book, which I already shown it's hard to prove, or two, lost licensing revenue from the monies obtained by licensing their works by AI model training data sets. Right? What Judge Chabra suggested in this market dilution theory is that a trained AI model may flood the market with competing works created by AI and then dilute the demand for the original works as a whole and depress the overall value of human authored works. Right. So there's a counter argument to this that humans can also read books or see pictures and images and create their own works. The difference is that AI models can do it a lot faster and then can flood the market. Now, the plaintiffs did not make this argument as part of their Factor 4, but this opinion essentially opened the door for plaintiffs to do so in the future. Now, the last case that I will talk about, and this is Doe v. GitHub. Okay, Dan, you're proactive. So in this case, I think it may be relevant to a lot of folks here because a lot of companies use developers to develop code. And right now, a lot of developers use AI models to expedite code development. This is essentially became the norm, right? And depending on this case, which is on the interlocutory appeal, there may potentially be liability both to the model developers and also to the companies that use the models. So the story here, there's a class action lawsuit against GitHub, Microsoft, and OpenAI due to their GitHub Copilot product. And that's the AI coding assistant that's trained on GitHub repositories. Also a case pending in the Northern District of California in front of Judge S. Ticker. So the allegations here is that the Copilot was trained on large-scale open source code repositories that included code by MIT, GPL, and Apache licenses. And once trained, the Copilot will essentially generate verbatim or near verbatim code from the licensing repositories without attribution, copyright notices, or licensing terms. So the plaintiffs filed 3 claims. The first claim is copyright infringement, right? Then there was the violation of the open source licensing claims. And finally, the violation under DMCA 1202, which is for the removal and omission of copyright management information from the outputs. Right. In the response, defendants essentially said, so defendants are GitHub, Microsoft, and OpenAI, and they argued that training on publicly available code is lawful and transformative. So that's in line with the Anthropic and Meta cases. They also claim that Copilot does not store or reproduce code in a way that constitutes infringement. So that's again in line with how AI models are trained, as Raquel explained. And then any similarities for the AI output, so the AI model generated code, are rare, incidental, and not systematic copy. So what did the court say? The court largely dismissed copyright infringement for both AI training and AI outputs. The court also dismissed largely open source licensing violations. And the main issue that remains is the DMCA 1202, and that's the remission of the attribution from the for the CMI output. Right. So what the court said here is something that's extremely narrow. So the DMCA claims, the court said, must, for the DMCA to apply, the Copilot has to generate a source code that's identical to the original. And the plaintiff said that that's way too narrow. Rather, the code that's substantially similar should also be included. Now, this issue is on the interlocutory appeal, and depending on how the appeal court will decide, this may affect both AI models developers and also the companies whose developers use the models. So what are the impacts? And I'll touch briefly before I turn this over to Raquel. AI copyright law still remains unsettled. The current trends are such that training AI models on copyrighted content is permissible because it's transformative. But at the same time, one has to make sure that the data sets are not pirated. So there is a shift from training to data provenance, piracy exposure, and also output regurgitation. So overall, this encourages the companies to monitor what their models are being trained and fine-tuned on. And with that, I will turn it over to Raquel, who can further discuss the impacts.
Thanks, Dina. Yes, and it's exactly what you said, right? Because we want to know, how do we protect ourselves? How do we pick data sets that minimize that copyright infringement? We saw it into the cases that Dina mentioned. One thing to be aware of is that many companies use terms of use that are very broad. And so we don't know where they're getting the data they're collecting. Are they collecting data that's potentially infringing? Are their terms of use very broad? And so key here is to understand where the data is being sourced. Do they have copyright agreements with them? And do they identify us? So have strong contracts in place that allow us to ensure that we are indemnified and to understand where this data set that's being used to train these models is coming from. And then internally, of course, is adding filters, adding flags, so that we can capture some of that when we're using these LLMs. Something that comes up also is in marketing. You want to use AI to create videos, to create images. So understanding what the tools are using, what the data is using as its data set before those LLMs create these images. So just something to keep in mind with regards to the data set itself. So we know we want to protect ourselves from infringing on data that may be possibly copyrighted. On the flip side is managing, excuse me, Dan, can you flip to the next slide? Is protecting ourselves from somebody using our data to train the next generation of AI models. We want to minimize issues with software generated by AI, also as mentioned by Dana. And then how do we prevent companies from obtaining our company workflows for training? It really comes down to making sure that you have a strong contract, understanding how to use these LLMs, have an LLM that's designated for the enterprise. Like we have an internal Claude system that is specifically using our closed environment. So that keeps us from having data, well, allows us to use data that is being trained internally. And we also want to have a clause that eliminates the data retention and prohibits storing of our data for training the models. It's all about having both internal controls and strong agreements and standards in the contracts that cover the data use and has specific vendor obligations in them. Now, we've got through some of the litigation that's happening. We've established some guidelines. I think it's also good to understand that there's the need for that IP governance. So Dan will run us through some of the support chain that exists within the copyright sphere. Dan, over to you.
Thanks. So, I wanted to focus in talking about supply chain restrictions in the use of AI, particularly in government contracting for AI technologies. And first, to offer an overview of U.S. government AI acquisition policy. This is kind of a rundown of the Trump administration's policies on procurement and use of AI by the federal government. The Executive Order 14179, issued January 23rd, essentially replaced the Biden era AI Executive Order. The Biden AI Executive Order was rescinded on day one of the new administration. And the executive order essentially set the groundwork for all the other policies. The two OMB memos, M2521 and M2522, provide more detailed information around the federal government's policies on using AI and on acquiring AI under government contracts. Maybe before saying a little bit more about that, Raquel already provided a functional definition of artificial intelligence. There is also a statutory legal definition in Title 15 and 94013. The term artificial intelligence means a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. And artificial intelligence systems use machine and human-based inputs to perceive real and virtual environments, abstract such perceptions into models through analysis in an automated manner, and use model inference to formulate options for information or action. So these two OMB memos replaced similar memos that existed under the Biden administration. Under M2521, regarding accelerating federal use of AI through innovation, governance, and public trust, the memo retains AI governance provisions and uses the new term high impact AI, which encompasses two categories that the prior Biden authorities had discussed: rights impacting and safety impacting artificial intelligence, kind of reflecting the federal government's unique role in using AI in government administration. There are some notable differences in that memo, kind of along the administration's policy preferences. So one of them was that climate and environment and elections were removed as from the scope of safety impacting AI. And there were also changes, removal of equity and algorithmic discrimination as rights impacting AI concerns. The other memo, M2522, driving efficient acquisition of artificial intelligence in government, set forth a number of different policies and guidelines for contracting for artificial intelligence, including a policy to maximize the use of American-made AI, which I'll talk a little bit more about with the first government regulatory clause governing AI technologies, the GSA AI clause introduced earlier this year. That memo, though, on acquisition of AI also addresses privacy protections, protecting IP, and requirements for handling of government data and disclosure of AI use, which was recommended that agencies consider risks of unsolicited use of AI systems by vendors and determine whether there are circumstances that warrant disclosure of planned use of AI. That's another thing we'll see in the first GSA clause. The other policy issuances by the federal government include the AI Action Plan, an executive order on preventing woke AI, and a national policy framework for artificial intelligence, not specifically geared toward procurement of AI, but dealing with which authorities and the balance of federal versus state authorities on artificial intelligence regulation. So the AI Action Plan introduced pillars accelerating AI innovation, building American AI infrastructure, and leading international AI diplomacy and security, and also addressed issues such as free speech and bias, eliminating any references to misinformation, diversity, equity, inclusion, and climate change. Also promoted public investment in AI, promoted the release of data sets used in federally funded research, and included a number of provisions intended to facilitate federal AI procurement and use. Preventing woke AI in the federal government addresses specifically federal government procurement of artificial intelligence, not by its terms the functionality of AI models in the private marketplace, but addresses the administration's views on ideological bias and social agendas that's built into AI models, which the executive order says can distort the quality and accuracy of the output. And so the executive order states policies for ensuring that artificial intelligence is not biased without going so far as to require retraining of models. The National Policy Framework for Artificial Intelligence essentially sets forth the Trump administration's vision for federal regulation of artificial intelligence, establishing a policy framework and preempting what the administration characterizes as cumbersome state laws, and so placing limits on the regulation of development and use of artificial intelligence at the state level, intended to improve efficiencies and create certainty and make it more practical to function in a multi-state environment. So some of the overarching themes for Trump administration's approach to AI policy and federal government use of AI and procurement include enthusiasm for widespread AI adoption across the federal government. This poster, "I want you to use AI," is in fact displayed around the Department of War. It's being heavily promoted, and at a time when the federal government workforce has been pared back, agencies are encouraging the use of AI to kind of fill the gaps and improve efficiencies as part of doing more with less. The AI policies to this point are geared toward addressing regulatory obstacles, including the aforementioned limits on state rules, also supporting AI infrastructure and promoting conditions to support AI adoption by the federal government. Overall, the emphasis is more on innovation and less on safety and governance, although the OMB memos do still include, again, provisions regarding minimum controls for high impact artificial intelligence. And of course, the federal AI procurement, like many other areas of policy, there are political elements in how it's being rolled out. So the policies in this area reflect the administration's opposition to diversity, equity, and inclusion, removal of climate change references, and uh, promotion of domestic sourcing, the American AI mandate, which I'll talk a little bit more about. A notable development over last summer in August was the Department of Defense IP cadre's publication of IP strategies for AI programs. So this was published as a supplement to the DoD IP guidebook addressing unique IP strategy considerations for AI acquisitions. And it kind of fits into the broader treatment of Department of Defense intellectual property strategy, which features a number of themes. The use of cross-functional teams, recognizing that the overarching objectives of obtaining sufficient intellectual property rights, data, and data delivery aren't just a legal function, that the entire program team and subject matter experts also need to be involved, including data scientists, AI/ML engineers, ethics advisors, cybersecurity experts, in addition to legal counsel. It also addresses the full universe of AI data categories, which presents some unique features, even distinct from other software that doesn't use artificial intelligence. So, considering the different varieties of data, from training data to model data, including weights, government furnished data, gets a lot of attention in all of the policies around government procurement of AI because of the types of sensitive data that the government has and will use in using artificial intelligence technologies. Outputs, testing, and validation data, also a very important area. Testing and evaluation of AI is critical given the national security implications of many government uses of artificial intelligence. And then system data, another area. So among the unique AI license issues addressed in the strategy document are, again, national security, high impact AI, concerns around explainability and audibility, given the specific types of government use of artificial intelligence, sustaining and retraining and transferring models. And then there are issues with open source licensing, which often is inconsistent with federal law. And then the overall approach deals with kind of tailoring of license rights and use rights around artificial intelligence technologies, which is really the broader strategy for IP. It's kind of in vogue in DoD acquisition. The other key theme is kind of planning for the IP and rights and data deliverables that will be necessary from the outset of the program, trying to compete and include, evaluation factors associated with intellectual property. Also planning for sustainment for the life of the program. Some of the government's unique needs revolve around the fact that they have programs that last for decades, and they need to kind of have a plan at the outset for how they'll continue to meet those needs. Some of that is addressed through modular open systems architecture and the use of data and model portability and interoperability so that parts can be swapped, AI technologies can be swapped in and out, and data can be moved from one platform to another. And then the tailored license piece is another major theme. So this kind of led up to the first federal government regulatory clause addressing AI systems, which was published in March. The General Services Administration issued a clause, Basic Safeguarding of Artificial Intelligence Systems, which was introduced through multiple awards schedule refresh 31. That is to say, it's part of was originally part of a mass modification to the General Services Administration multiple award schedule program. which is one of the largest IT acquisition vehicles in the federal government. Now that Refresh 31, there was some industry pushback because there was a very short window for providing comments on the clause, and so it was deferred for consideration in a future refresh, Refresh 32, or there are questions, as I'll say, about the future of this clause. But it is notable because it flags many of the issues that industry and government are going to have to deal with in contracting for AI technologies. One of the perhaps most notable features of the clause is that it's very detailed and includes a lot of government unique requirements, which is contrary to the general federal government scheme when it comes to commercial software acquisition. The FAR policy is that commercial software is supposed to be acquired under the licenses customarily provided to the public to the extent such licenses are consistent with federal law and otherwise satisfy the government's needs. So the standard approach to negotiating a software license or a SaaS license is to start with the license that the software provider uses with the general public, and then make adjustments, often through a rider, for federal legal restrictions. So things like removing open-ended indemnification clauses or automatic renewal terms that run afoul of the Anti-Deficiency Act, addressing governing law and venue, which are restricted by the Contract Disputes Act, assignment provisions that implicate the Anti-Assignment Act, and so forth. The GSA clause is totally different, has very detailed requirements. It's prescribed for solicitations and contracts for artificial intelligence capabilities. So not only instances where AI is a deliverable, but also instances where AI will be used in contract performance, at least the way the clause is framed. The contractor under the clause is responsible for compliance by service providers. So this is one of the other big areas where industry provided feedback. The clause makes contractors responsible for any entities that directly or indirectly provide, operate, or license AI systems, whether or not they qualify as subcontractors. And by most commentators' reading, the clause really goes much further than a typical government flow-down clause, for example, where the contractor has the obligation to flow down the terms of their agreement with the government to the extent called for in the clause, but it doesn't have very extensive oversight capabilities. There's some level, but the provisions around compliance by service providers and contractor responsibility go far beyond what would be typical. And it would also require contractors to renegotiate existing commercial agreements to meet the prescriptive government unique requirements. And it states by its terms that it takes precedence over conflicting commercial terms. And while there is some ability to tailor the clause, there are some provisions like disclosure, incident reporting, and American AI restrictions that can't be modified for individual orders. So, quick overview of the key requirements. The license parameters, no refusals. The clause provides that the government has the right to use AI for any lawful purpose. And of course, this is a phrase that has come up in the dispute between the Department of War and Anthropic in the supply chain supply chain designation dispute, which I'll talk about in a minute. The clause also goes further and gives the government the right to integrate the AI system with government systems, also to the extent needed for any lawful purpose. It also confers broad ownership rights in government data, inputs and outputs, custom developments, and that includes modifications, customizations, configurations, or enhancements to AI systems. Kind of more sweeping IP rights in different categories than would be typical in a commercial setting. And it includes the results of model training or fine-tuning and outputs, not only including generated content, but derivative data, metadata, logs, and synthetic data. There are also extensive restrictions around government data handling, restrictions on data use, including restrictions on feedback that includes government data. this rule around American AI, a mandate to use only American AI systems, and prohibition on using foreign AI in contract performance, including any AI components manufactured, developed, or controlled by non-US entities. There are also provisions on disclosure of AI use, oversight of by humans of the AI technology, and traceability requirements, incident reporting, change management. It incorporates the unbiased AI principles, which go back to the DEI woke AI executive order, and also include requirements for data portability and interoperability. So this clause may well be pulled back. It's unclear how it will shake out, but it kind of sets the parameters for negotiations between government and industry. So I think with that we're at time. Is that right?
Yes. And
All right.
Hello. At this point, we will conclude this session, the formal part of the session. On behalf of the chapter, I'd like to thank our sponsor, Haynes Boone, and panelists Dan, Dina, and Raquel.